The next case is Fred Prouse versus Judith A. Pasternak. One second, let me get my... How much time would you like for rebuttal?
I'd like 6 minutes, Your Honor.
6 minutes? Okay, perfect. Whenever you're ready.
Thank you. May it please the Court. My name is Patrick McGee. I represent the appellant Fred D. Prouse as beneficiary of the Marjorie V. Prouse Trust. Mr. Prouse and his two sisters became co-successor trustees of the MVP Trust upon the death of their mother, Marjorie Prouse, on August 7, 2013. Mr. Prouse sued his co-trustees, appellees Judy Pasternak and Martha Milnes, in March of 2015. And Mr. Prouse sought removal of his two sisters as co-trustees, and he asserted a separate count for breach of trust. The suit was founded upon the refusal of these co-trustees to disperse any of the trust's entirely cash assets of more than $1.3 million unless Mr. Prouse acquiesced to the written and unfounded demands made by the two sisters and a disinherited fourth sibling, Joseph Prouse.
The trial court ultimately determined that he had not proven a serious breach of trust, correct? That was basically what the trial court determined.
Well, what she said, and she didn't say much, was that the evidence did not sustain a burden of showing a basis for removal of the co-trustees, and then...
But you have to find a serious breach of trust in order
Absolutely.
for it, and so she ultimately didn't find that.
Ultimately, you'd have to presume that's what was intended, and then you have under the statutes, you have all of these different standards of care, and a breach of those standards of care under the statutes is a breach of trust. Removal of the trustee wouldn't be for any ticky-tacky sort of thing, but it had to be a serious breach of trust.
But isn't that a factual determination that the trial court had to make?
I think the trial court had to make a determination on the facts, and the facts that related to Mr. Prouse's claim, they are not disputed facts. They were based upon the written statements of the co-trustees as to what they were doing and why they were doing it, and their sworn testimony, both in deposition and trial. So what the trial court did was take these facts and say, under these facts and the statutory standards that apply, there's no breach of trust, and there's no serious breach of trust or a reason for removal of the co-trustees. We think this case is similar to a case that we cited in our brief regarding the standard of review, the Brigham versus Brigham case. And there, the courts said that the trial court's failure to apply several trust statutes are matters of law to be reviewed de novo. So we're not asking this court to overturn findings of fact on disputed evidence. What we seek is the court to apply the relevant trust statutes to the facts that were established at trial. And in the Brigham case, facts were established at trial, but the trial judge failed to apply the relevant statutes under the trust code, and on appeal, the outcome in Brigham was reversed, and when the appellate court applied the appropriate trust statutes. And so you can see here the analogous circumstance where you have facts in which the appellees state in writing what their intentions are, their bad intentions were, why they were doing it, and when asked about, well, why didn't you respond to any of this? They said, well, I just, Fred Prouse's demands, they said, I just didn't. But they state very clearly in their written emails to Mr. Prouse what they intended to do. And this is cited in our brief starting on October 1, 2014. And to set the time frame, October 1, 2014, we have a Martha Milnes email that I'm going to talk about that sets the stage. The month before, the trust's home was sold, so now the trust is entirely liquid, over $1.3 million in cash, all in their attorney's IOTA account at that point. And the month before that, the two co-trustees had conducted a meeting. They called it a meeting of the trustees of this separate Prouse, Fred R. Prouse Trust. Now, Fred Prouse, the son, Fred D. Prouse, was the sole trustee of that trust, and there were 3 beneficiaries, the same beneficiaries as in the
And they
MVP
disputed
trust.
that because he didn't sign the amendment. It was actually signed by Marjorie, right, as her power of
Yes,
attorney. So there was a dispute over that.
And that was the argument made in the later lawsuit that they filed after that in Indian River County, which they lost and on summary judgment and eventually dismissed that suit. But what they had claimed, these 3 individuals, Martha Milnes, Judy Pasternak, and the other brother, Joseph Prouse, that there were 4 trustees of the Fred R. Prouse Trust, that the trust amendment that changed the beneficiaries was invalid, that Fred Prouse was obligated to disperse the Fred R. Prouse Trust cash assets in 4 equal shares within 15 business days, that he was obligated to sell the condominium owned by the Fred R. Prouse Trust and disperse that in 4 ways, not 3, that the Fred R. Prouse attorney, who was me, was to be terminated. They said Patrick McGee was to be terminated as the attorney for the Fred R. Prouse Trust. So that's what they provided with to Fred Prouse in August of 2014. September, the home was sold. October, Martha Milnes writes to Fred Prouse, copies her co-trustee Judy Pasternak, and says, the reason we're not dispersing from the Marjorie Prouse Trust is you object to our position that you are not sole trustee of the Fred R. Prouse Trust, that you believe Joseph V. Prouse is neither a trustee nor a beneficiary of the Fred R. Prouse Trust. And we are not discussing at this point procedures for distribution that do not involve closing out both trusts. So at that point in October 1, the co-trustees start holding as hostage all of the cash assets of the Marjorie V. Prouse Trust, which they say in the same email that we are ready and willing to close out. We're ready to disperse, but we're just not going to do it.
In terms of the instant litigation, Fred, it seemed, had 2 real goals. One was to get the trustees, his sisters, to disperse the money, correct?
Ultimately, yes.
And didn't they enter into an agreed order granting that specific relief?
Yes, they did. And let me
And his
talk-
other goal was to have them kicked off as trustees.
Well,
correct?
we still have $135,000 remaining in the trust. That it's still there, and the time frame involved here is that the trust was liquid, 1.3 million plus in September of 2014. Fred Prouse is asking for distributions to be made, and this is set forth clearly as to what the numbers are. Here's how much we have. Here's how much for a reserve. Here's how much that should be dispersed. If you disagree, please tell me why. If you think the reserve is inadequate, please tell me why. Not a response. He writes them again in February of 2015 now. Still no response.
And their only reason for not dispersing from the MVP trust was because he wasn't dispersing yet from the Fred Prouse Senior Trust, correct?
Correct, with some footnotes to that as well that make it worse for them. And one is that they were suing him at that point in time, claiming that there were 4 beneficiaries, not 3, and claiming that he's not the sole trustee, that he's not even in control. He can't sell the condominium, and because he can't sign a deed. He's going to have to disclose the fact that there's a claim that he's not the sole trustee of the Fred R. Prouse Trust. So this goes on during the entirety of the rest of 2014, the entirety of 2015. And into 2016, he again sends them a letter saying, will you please, just, if you don't like my plan for dispersing, do something. And they won't.
There also evidence presented at the trial that one of the reasons the distribution of the Marjorie Trust was not made is because Fred consistently challenged the valuation of that trust. And they couldn't agree on the numbers. He kept objecting to different numbers, like the $180,000 loan and the payment for the caregiving and those types of things.
That argument that was made by counsel is a bogus argument. The claim is that
Mr. Brennan also testified to that as well?
No, he did not. No, he did not. Mr. Brennan had some very narrow testimony where he said these awful disputes need to be resolved before the trust corpus is dispersed. So we're talking about the
disputes were some of the objections that Fred was raising to the value of the Marjorie Trust.
Let me address that. There are a couple of elements to that. One of them is Mr. Brennan, and he was asked, did you advise your clients to not make partial distributions? And he testified specifically, I didn't advise them to do it, and I didn't advise them not to do it. I didn't advise them either way on that. As to the value of the trust, that relates to some 3 objections that were filed in the estate, not in the trust. The objection to the Megan Pasternak payment and to some of the trustee expenses. Those were involved, and that was part of the reserve. The other issue was the $180,000 mortgage note checks that had been loaned by the Fred R. Prouse Trust to Marjorie Prouse with a mortgage on her home. That was covered by an escrow agreement, and this is all covered.
The $180,000 dispute, was that resolved on the first day of trial by that agreed order?
Yes, it was. What you had going into trial, up to trial, and this is from September of 2014 to December of 2016, was the refusal of the co-trustees to disperse because Fred Prouse wouldn't agree to these various claims that were being made about the separate trust. The trial proceeded for a very short period of time, till about 11 o'clock in the morning. Judge Harris abruptly cut off the evidence after a question was asked, said we're moving courtrooms. When it comes back on the record, what you have is obvious remnants of a discussion that had occurred off the record, and that's not in the record as to what occurred, but at that point, the parties agreed, the co-trustees agreed that they were going to disperse the lion's share of that. I made the point that the only reason they are now agreeing to disperse all of this is because they were finally in front of a circuit judge who can order relief to occur after all that.
So at that point, they essentially agreed with Fred's position on the $180,000. They agreed with regard to Megan's claim for wages that should be a claim against the estate, not against the trust. Is that right?
Not entirely, but close, yes.
And then as far as the trustees' expenses, they agreed to provide receipts or documentation for their expenses.
Receipts. And we agreed that we'd hold $135,000 in trust at that point. And I said on the record at that point, we're still going to have to come back and determine whether the failure to disperse from September of 2014 up until December of 2016 was wrongful. You're still going to have to deal with that conduct of whether
So
it was wrong.
the only issue really left to litigate was whether or not there was a serious breach of trust and they should be removed as trustees.
Both of those, whether a breach of trust claim and whether there was grounds to remove them as trustees and be replaced by some other trustee or have some third party come in and close out the trust. That's correct. So the issue is whether the trustees' conduct, as they agree in writing, it was, we're not going to disperse anything from this trust. And the reason we're not is as stated. That's wrongful. That's not permitted. That's a breach of the duties under.
There's a standard of care for trustees.
Yeah. The
And
breach.
there was no expert testimony presented, was there, that somehow these folks breached that standard?
No, the statutes state what the standard of care is. We could have brought an expert in to tell the judge what the statute says, but that would have been inappropriate. We have a case that we've cited in our reply brief to indicate that unless the statute, if the statutes that sets the standard of care is in ordinary words, expert testimony is not only, it isn't permissible.
Apart from the distribution issue, you asked for their removal, I think you allege in your complaint, because they acted in their own interest and not in the interest of another beneficiary being your client.
Yes, that's one of the issues, yes.
What evidence was there to show that they did anything that benefited them and not your client, to his detriment?
Well,
'Cause all of their decisions seem to have affected the three of them equally.
On the monetary sense, ultimately.
They didn't make distributions to themselves, right? They didn't do partial distributions to themselves. They didn't draw any kind of fee for their services. Did they do anything that benefited the two ladies to the detriment of your client?
Well, yes, they paid their attorney's fees for suing Fred Prouse as trustee of the Fred R. Prouse Trust in Indian River County. They paid
Is
that
that alleged
out.
anywhere as a breach of trust?
Is-
Is that alleged as a basis to remove them?
No, and I was responding to your question of whether under those circumstances there was anything that benefited just them. But it's not just monetary, it's what their intentions were. They wanted, for whatever reasons, they wanted to be co-trustees of the Fred R. Prouse Trust. So while it didn't benefit them financially to hold that money back, they were trying to use that to benefit their other interests. They wanted to be co-trustees of the Fred R. Prouse Trust and take control. They wanted to add their other brother, as an additional beneficiary of the Fred R. Prouse Trust. So yes, they were acting in their own personal interests and not for the benefit of Fred R. Prouse Trust as beneficiary.
So wanting to serve as co-trustees in the Fred Trust is a serious breach of their trust obligations in the Marjorie Trust?
No, but saying that we're not going to make any distributions from the Marjorie V. Prouse Trust when they should have, unless Fred D. Prouse agrees to these certain things, that is a breach of trust. I'd like to reserve the rest of my time unless there are questions at this point.
May it please the court, good morning. My name is John Pappas, and I have the privilege of representing Judy Pasternak and Martha Mills in this case. First, I'd like to read the removal statute, portions of it that apply for count one of their complaint, 736-0706. The court may remove a trustee if the trustee has committed a serious breach of trust. And they use the word may 3 more times in this statute.
Is it ultimately a factual determination that the trial court has to make to determine whether or not there's been a serious breach of trust?
Absolutely. Absolutely. And the point Your Honor May just made with regard to expert, yes, the statutes provide a statutory standard, but in order for the trier of fact, the judge in this bench trial, to know whether that has been breached, there needs to be an expert saying it's breached. The closest thing to an expert was Mr. Brennan himself. Mr. Brennan was the attorney representing my clients on the trust issues. And Mr. Brennan, court found that privilege was waived. They called Mr. Brennan to the stand in their case in chief. And he testified, and I'm paraphrasing, but in the briefs it's directly quoted, all they wanted to do was get it resolved legally. All my clients wanted to do was get it resolved legally. They sought my advice. They always took my advice. I do not recall categorically mentioning one way or another whether to make a partial distribution, but it was completely reasonable, this is his testimony, completely reasonable to want to resolve all the obstacles of the challenges to the corpus before making any distributions.
In terms of the challenges, did they total, what, like $250,000, maybe 300,000, something in
Yes.
that range?
Yes, it evolved over time, and almost cutting to the chase, as you pointed out, the first day of trial in 2016 in October, before a court, with the power of the court to oversee it, without waiving issues and saying it was owed or anything, my brother, who at the time tried the case, represented to the court that, look, we don't waive anything, Your Honor, but we're glad to be here. Let's resolve it. And it was resolved. There were issues about whether the $180,000, which was never really a distribution challenge. It was a creditor. So their refusal to pay the FRP trust $180,000 in no way harmed any of the trustees of the MVP trust or Mr. Prouse as a beneficiary.
But it delayed payment.
Absolutely.
And
Absolutely. The challenge delayed payment.
In terms of bringing the suit, would you agree that one of the primary goals Fred had, and I'm just using people's first names, not out of disrespect, but to keep it simple, one of the things Fred wanted was for the distribution to occur, and on the first day of trial, that was agreed to, correct?
Yes.
And
He
one of the things he sought by way of that was the $180,000 was owed to the Fred Senior Trust, correct?
Yes.
And then in terms of the Megan wages, those were owed, but not from the Marjorie Trust, maybe from the estate?
Well, I'll clear that up, the last part in a minute.
Okay.
But understand, if you look at the entire record, my client's position by them, as well as through Mr. Brennan, from day one was, let's distribute. We want to distribute.
Was there any justification for delaying the distribution from the Marjorie Trust based on the Fred Senior Trust not being distributed?
Was there any basis for it?
Was there any justification for it under Florida law? In other words, can you say, we're not going to do our duty here and distribute, even though we've got the cash, we'll save $300,000 or $400,000 or whatever it is for the disputed claims, but we're not going to distribute this liquid cash over which there's no dispute unless you agree to do what we want or we reach an agreement in the Fred Trust.
I understand. Remember, the FRP Trust had the exact same beneficiaries as the MVP Trust. They're the same beneficiaries.
But it had a lawsuit filed against them.
Right. And I disagree with the one word you use, the duty. They had no duty to make a partial distribution, ever, period. They had no duty to do that. And their duty was to take the totality of the circumstances and try to figure out what to do. And they did it. They hired competent counsel to represent them who testified. They never told me not to take do a partial distribution. They never told me what to do. They relied upon my advice, and we did the right thing. We're waiting for the challenges to the entire corpus, and if the challenges are good, it reduces the corpus before making any partial distribution, including partial distributions to the niece and the nephew for $50,000 apiece, including partial distributions to my own clients. They admit there was no self-serving behavior. They were entitled to take compensation for their services. That was a lot of hours. They waived it. They said, we don't want to do that. And he had no hours, Mr. Prouse had no hours involved in it. But count one is for removal, only removal. This option stuff referred to by counsel is not in the pleadings for count one. Count two is solely for breach of the trust. And an element of that is damages. They introduced no evidence of damages as a result of any so-called breach of trust.
They could have under 736-1001, they could have asked the court to force your clients to make the distribution, couldn't they?
Yes.
And they did not?
They did not. They make claim for like, one of the most important points is on the first day of trial, when we had We wanted to go before the court. You know, courts take time, and we understand that. So we now have an opportunity before the court, with the protection of the record, to make distributions without suffering consequences. And that was done. We offered to distribute 100% of the corpus. 100%. And remember, they were arguing that it was kept in a non-interest-bearing account for a long time, although they never actually moved the courts to move the corpus into an interest-bearing account. Never did that. But counsel for Mr. Prouse says, no, 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 we don't want you to distribute the entire corpus. We want you to keep $100,000. 3 times we said before the court and before counsel and Mr. Prouse, we want to distribute the whole thing. There's no reason not to. There's no reason to come back a year from now and trying to remove our clients as trustees or try to find them in breach of trust for a year later. No, he insisted $100,000, and then he insisted, Mr. Prouse, through counsel, insisted that in addition to the $100,000, hold back $35,000 for a total of $135,000. And we said, why? He says, because we're still challenging the corpus because the trustees wrongfully, out of the trust, paid the niece, Megan Pasternak, for 24/7 care services for her grandmother for 315 days. And we said, really? And he says, yes. Well, 11 months go by, and we come back for trial. There's only one reason coming back for trial is because their insistence on not dispersing the $135,000 that they insist to be put in, which remained in a non-interest-bearing account for the next 11 months at their essentially request. Then what happens at trial? They just 2 days before trial, they depose Megan for 2 hours, and then they argue before the court that it was wrong for the trustees, my clients, to settle. She had to file a suit against the estate to get paid for her care and services. So Megan had to hire an attorney, and she never recovered the cost for the attorney. She had to pay it out of the $35,000. But they said, look, we're not going to reduce our corpus by paying fees to defend against a legitimate claim of Megan. They paid the $35,000. They were challenging it. We waited 11 months so they could challenge it. And what was the testimony? Oh, we agree that Megan did 24/7 services. We agree that her grandmother, the deceased, that she wanted those services performed. And we agree she did a fantastic job. And we agree that, she's not lying about anything. But we think it was wrongfully paid by my clients for 2 reasons. They're claiming $13 an hour for her services when we believe it should only be $12 an hour. And 2, the deceased, her grandmother, had bequeathed her, Megan, $50,000. And we interpret that $50,000 that was bequeathed in the will to have been compensation for her services. No evidence of it whatsoever. In fact, the evidence was otherwise.
Did they contest, though, whether it was a debt of the estate versus the trust? I mean, did anybody contest that it should be paid by the trust rather than by the estate?
Well, it was, I believe, to be honest with you, I think it was paid by the estate, which then merged into the trust, is my understanding. But their challenge was that...
What happened in the agreed order regarding Megan's wages? Was that agreed to or not? The first day of trial, there was an agreed order?
No, they refused.
That's
what they challenged. That's the reason why we stay. That's the reason why we had a 1.5, 2-day trial 11 months later. At their anomalous or ironic or paradoxical request that $135,000 be kept in the non-interest-bearing account for the next 11 months. And we want to argue before the court that The $35,000 is what is the basis for removing them now as trustees after 80% had already been distributed in a breach of trust. And so you know, they had no argument. The $50,000 bequeath was another $50,000 she had bequeathed to her nephew, Mr. Prouse's son, who had never provided any services whatsoever. So they had no basis for it. It was respectfully a completely bogus and frivolous challenge, and their own people testified to it. We did not put a witness on the stand. When they closed their case, all the witnesses who testified were in their case in chief. They called Mr. Brennan, who testified completely in behalf of my clients, that, you know, as far as he's concerned, they did nothing wrong. They followed the trust and they fulfilled their duties. Ms. Mills, Brennan did not remember, he said. I do not recall categorically telling him not to do a partial. Ms. Mills testified a couple of times that she did remember that Mr. Brennan had said, no, the best thing to do is identify the total corpus. And just so you know, the reason why, even though there was no obligation to make a partial distribution, the reason why things were not distributed was not because of the tie-in to the FRP trust. The reason ultimately why things were not distributed was one reason: the challenges to the corpus. They were concerned with a look, obviously, it was a family matter and people didn't get along, to say the least. And they were concerned about litigation. They were concerned about fees and costs. They were forced to spend over $50,000.
Did
In
Mr.
fees.
Prouse at trial testified, did he not, that it would not be prudent to give a partial distribution when there's ongoing litigation?
Absolutely.
correct?
In all fairness to him, he was questioned on cross, and he said, no, I would be concerned as long as there's challenges to the corpus as co-trustee of the MVP trust, and apparently as sole trustee of the FRP trust. He testified, no, as a trustee, I'd be concerned about making partial distributions as long as there are challenges to what is in the corpus, the total corpus. He did say, but, you know, I might do it if we take a certain amount in reserve. He did say that. Mm-hmm. But he was concerned. I mean, you know, we're not talking about professional trustees here. I mean, the standard that they're applying at the lower court level and certainly on this appeal would result in any time you have 3 trustees and one trustee wants to make a distribution, partial, that you're going to have, if you rule in their favor on that issue, you're going to have inundated case law and appellate decisions. You're going to have interlocutory appeals. You're going to have injunctions. It is common that 3 trustees do not unanimously agree, especially on making partial distributions. It was completely reasonable for them to say, let's first resolve all the issues. All the issues were not resolved until the judge ruled, because they were still making claim for the $35,000 he put back into the corpus because it was wrongfully paid for by my clients. As far as anything else, I mean, yellow light is on. It's always amazing how quickly time goes by in these proceedings. And although I had a lot of other things to share with you all, do you have any questions of me? I don't wish to waste any time.
We don't have any questions.
Thank you very much.
Thank you. I have a lot of items I'd like to cover quickly if I can. This 100% offer on the first day of trial to distribute, and the reason there was a holdback was because there had been some unknown amount of fees, at least in the tens of thousands of dollars, paid in connection with the Fred R. Prouse litigation that the co-trustees paid to themselves. There had been no accounting. There had only been one accounting in 2015. and there had been no accounting as to what was in there. There were expenses that the trustees, co-trustees had paid themselves without receipts. There were reasons that the entire amount couldn't be dispersed, and I could see why they would say, let's just disperse everything, because that would have been to their benefit. But there were items that needed to be looked at. These other items relate to the estate itself, which the judge put into the trial almost a year later, and the Megan Pasternak issue. Just briefly, Fred Prouse had asked repeatedly, what was the agreement to pay? We understand services, and there wasn't any dispute about $12 versus $13 per hour. That's not in there. It was, what was the agreement? Finally, after protective orders, we got to take her deposition 2 days before trial and learned that she said that my grandmother said you're going to have to wait until after I die before you can get paid. Well, that's what the agreement was. That's not enforceable, and we provided that to the judge at the day of trial. We dealt with that. We just wanted to know what the facts were, but we couldn't get that information from them. Fred Prouse asked, and on the damages issue, the damages were mentioned. It's the statutory interest, among other places, the transcript page 80. If the distributions should have been made and they weren't, there's a loss of use of money. If there's a statutory interest, which is damages, plus under 736-1001, any breach of a duty, one of these statutory duties, is a breach of trust under the trust code.
In your complaint, did you ask the court to compel the trustees to make payment or make distribution?
We did not ask the court for that specific remedy, but we had some catch-all phrases in our complaint, or such other relief as the court deems proper. I suggested to the court in our arguments, opening and closing, the court had a number of remedies that it could impose. It had a lot of choices that it could make, but it chose to do nothing under those circumstances. And to clarify Mr. Prouse's testimony, he was asked specific questions. If there's a problem, if there's a question about who the trustees are or who the beneficiaries are, no, you don't distribute. That's to Fred R. Prouse. He said, but there are no such issues in this case. And if there were other issues, you might have to hold something back, but yes, you can distribute. And then he was asked about the trust corpus. So to suggest that Mr. Prouse was saying, no, there shouldn't be distributions when there's any sort of disagreement in this case is just not what the record reflected. And the Fred Prouse complaint, not these other estate issues, was about, is it okay for the trustees to say, we're ready to distribute, we have $1 million and more in cash, but we're not going to do it unless you agree to our desires concerning a separate trust. That's not conduct that should be condoned, that should be permitted. There are all kinds of statutes and standards of care that have been breached. We respectfully ask this court for relief. The conduct of Ms. Milnes and Ms. Pasternak should not be condoned by the courts of this state.
Thank you. Out of time.